We just check. Broadcasting has resumed. Can I remind members to turn off their mobile phones completely? And before we commence the main business, I want to turn to the correspondence, if that's okay. The minutes. The minutes of the 3rd, 4th, 9th, 10th, 16th of April have been circulated. Are there any matters arising? No matters arising. The minutes are agreed. Correspondence. In relation to our recent hearings on governance and related matters at the FAI, we received a significant amount of correspondence. So I'll just read the items. 2019-446 A, B, C and D, email from Ria Walsh on the interim CEO, Football Association of Ireland. Correspondence 2019-447 A, B and A, email from Colin McGinty, Sports Ireland. Correspondence 2019-449 A, B, A, email from Colin McGinty, B, correspondence from Sport Ireland and the FAI. Next item, 2019-450, documentation received from Deputy Catherine Murphy. Next item, correspondence 2019-452 A and B, email from Ria Walsh, Interim CEO of Football Association of Ireland, 15th of April. Correspondence 2019-453, email received from John Tracy, CEO of Sport Ireland. Next item, correspondence 2019-454, correspondence from Minister Shane Ross, providing letter received from Donald Conway, President FAI. Next item, correspondence 2019-455, correspondence from John Tracy, CEO Sport Ireland. Next item, correspondence 2019-457, email received from Mr Tom McNeice on the same issue. Correspondence 2019-461 A and B, email from Mr Colin McGinty, Sports Ireland. We have discussed these and relevant matters in private session, and it is proposed to note this correspondence, which it'll be on our website. It won't be, yeah. So anybody who's interested in those letters, they will be on our website. Is that agreed? Agreed. I will now turn to other correspondence. 2019-459, email from Larry Larkin. It's proposed to schedule a meeting as soon as the committee schedule permits. Is that agreed? It's they want to make a presentation on an anomaly regarding representations of Irish athletes completing in international competitions. The letter is there. Basically, they're saying that certain athletes can't be included in national teams. I think it may have an issue with. The best thing is for them to explain it.
Yeah, that's been gone through a number of years ago. All of that. It's an issue with the federation.
So we can ask them to come in.
But it's just it's a repeat of what.
It's a waste of time.
That's the thing, Nick. There's no.
You know.
Yeah.
I'm in your hands.
We invited people in here before, Chairman, and the people who advocated that we invited them in didn't even turn up to meet.
Okay, well, that's a good start.
Yeah.
Look, I'm in your hands. What will we do? We note that correspondence.
Maybe defer to the next meeting, because I'm not even sure what it's about.
Yeah, we defer.
I think if, sorry to the chair, if you ask them what solutions are they proposing and who can provide these solutions, I don't think it's this committee, to be honest.
Okay, well, I think that's the view of the meeting then. So we'll write and ask them to give us more detail on what their proposals are.
Yeah, and what they see as the solution and who outlines, who
no problem. Okay.
has control of the solution.
Next one, 2019-460, email from Damien Black, Air Navigation Safety and Security Division regarding pre-legislative scrutiny. Proposed to note this correspondence with subject to our meeting today. Is that agreed? Agreed. Correspondence 2019-462 A and B, email from Darren Clark, Department of Transport, correspondence about the 100,000 cricket loan. So we propose to note that correspondence. Is that agreed? Agreed. Correspondence 2019-463 A and B, email from me. It's from John Kavanagh, head coach, regarding submission of the Irish Mixed Martial Arts Association. So it's just, if members would like to, we could ask them to come in if they want to give us a presentation at the appropriate time. That's agreed. When we go to do our work programme dates, we can take it forward. 2019-464, correspondence from the Clerk of the Dáil regarding the private members' bill on RTAs that have been read a second time. Proposed to note the correspondence. Note that the sponsor of the bill must make a scrutiny request to the committee in writing, and we await that. Is that agreed? Agreed. Correspondence 2019-444, email from Paul Allen about the Irish Cruise Ship Action Group. and this is a hot issue for people both in the port who are under huge pressure in terms of space.
That we bring I propose that we bring the stakeholders affected in before committee.
And could I suggest on that, as a member of a different committee, I got a briefing on Dublin Port as to what how they, it might be worth a while that the committee could go down there before the meeting. Now, it might take an hour and a half to just see exactly the pressure. Pardon?
It'll take longer.
It would take longer if we're going to have a tour.
Yeah.
I think it's worth doing because the implications for transport on Brexit and all of that are hugely part of it as well. So maybe if we do that visit to the port and then invite in the people who are concerned then after that, would members find that reasonable? Yeah. Right, so we'll do that then. Okay, correspondence item 2019-448. Email from Donal O'Céidigh dated the 8th of April concerning the bicycles on intercity trains. Can we note that correspondence? Should we send it to Irish Rail?
He's already
sent it, yeah. Can we send it to Irish Rail? Oh, he sent it to her.
Yeah.
Right, okay, well,
Okay, sent to Irish Rail.
we'll send to Irish Rail, right, okay. Correspondence 2019-451, email from Katrina McLean regarding detachable ramps and wheelchair accessible taxis. Propose to note that correspondence. And just on that point, the Minister is supposed to come in to discuss with us the issues in relation to disability and transport implementation. So we write to him and seek an urgent date. He cancelled a couple of weeks. Well, I think let's get him in.
Yeah.
Is that agreed? We'll ask him in to give us that update. We're nearly finished this. Correspondence 2019-456, item 2019-458, email from the Office of Minister for Transport concerning future reappointments of 2 persons. So it is proposed to schedule this meeting as soon as the committee permits. Is that agreed? Is that agreed? And now at this stage, I'm on topical issues in the Dáil, so I have to go. Yeah.
457.
Sorry, Commissioner.
457 correspondence.
Sorry, 4 apologies there. 474.
No, 457.
457. Email from Tom McNeese dated April concerning the FAI in relation to the auditing firm. Is that?
Yes.
We did, yeah. If you wish to raise something.
Have you made a...
You're in the chair now.
Well, no, Chair, I suppose it is being asked the question, it's been asked about auditors, like, how come you only woke up when the media took hold of the issue, like, should we write to him, like, maybe write to the, I don't know, the accounts.
Do you want that his correspondence will be sent to the CRO or to the FAI? See, the problem with the CRO, that's the matter before the courts now.
Oh, no, I'm not talking about the FAI here, Chair.
Not that
it is the auditing firm, like, how come it's 3 years later they decide to launch a... Why did you only come up now with going to the corporate enforcement offices, like,
Okay.
That's the big question, Chair, like, is why is it only now that the accounting firm, like, decided to lodge a complaint? 3
See,
years
the
later?
problem, I don't have a problem writing to him at all, but if the matter... this is the legal stuff, but if it is the subject of an investigation that could have a criminal outcome, because that's what we've been informed that it is, and it's also a matter before the High Courts currently. It might be wiser to wait until that has ceased or finished.
Well, can I suggest so
because
that...
we're in public session, I just want to...
Yes, I
private session if you
can I
wish.
suggest, so, Chair, that if that question is not resolved at a later date, we revisit it, or maybe refer to PAC, even like the PAC committee. Maybe.
Of course, yeah, no problem.
Thanks, Chair.
Now I'm going to ask you to take the chair. That's fine. I've got, so I'll just adjourn for a second while I... Yeah, whatever. Okay. Thank you, thanks. Such.
Right, as we're in public session, can I again remind members, witnesses and those in public gallery to please turn off their mobile phones completely as they interfere with the recording equipment. The purpose of today's meeting is the pre-legislative scrutiny of the general scheme of the Aviation Regulation Amendments Bill 2018. And in this regard, I would like to welcome Ronan Gallagher, Department of Transport, Mr. Michael O'Connor, and Brona Tracy, out of the Department of Transport. I welcome all today, yes. Oh, sorry, and David Hodgins is also in our company. Before we commence on the council procedures, I am required to read the following. By virtue of Section 17/201 of the Defamation Act 2009, witnesses are protected by absolute privilege in respect to the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that not only evidence connected with the subject matter of these proceedings is to be given, and you are asked also to respect the parliamentary practice to that effect. Where possible, you should not criticise nor make charges against any persons or entity by name in such a way as to make him or her identifiable. Members are reminded of the long-standing parliamentary practice to this effect, that members should not comment on, criticise or make charges against either a person outside the House or an official, either by name or in such a way as to make him or her identifiable. So now I invite Mr. Ronan Gallagher to give his deliberation.
Chairman.
Thanks, Ronan.
Chairman, the Minister has asked me to thank you and the committee members for setting aside the time to facilitate pre-legislative scrutiny of the general scheme for the Aviation Regulation Amendment Bill 2018. The Government agreed in November 2018 to the drafting of legislation to give effect to the objectives of the National Policy Statement on Airport Charges Regulation. Under the Aviation Regulation Act 2001, the Commission for Aviation Regulation, CAR, regulates airport passenger charges levied by DAA at Dublin Airport. Under the regulatory process set out in the current Act, CAR establishes the maximum charge per passenger that the DAA can levy at Dublin Airport over the following 5-year period. This is effectively a price cap on what the DAA can charge airlines for various services it provides. Within the limits of this overall price cap, DAA sets variable annual charges in respect of specific services, such as aircraft landing and parking. In 2015, the Department initiated a review of this regulatory model, involving an independent economic assessment and report by Indicon International Economic Consultants, and a public and industry consultation process. As a result, the revised regulatory policy, the National Policy Statement on Airport Charges Regulation, was drafted and then approved by Government and was published in September 2017. The general scheme contains the necessary legal amendments required to give full effect to this revised policy, as set out in the statement. The key points of that policy statement, which this general scheme addresses, are: Dublin Airport will continue to be subject to price regulation in recognition of its significant market power. The primary purpose of the regulatory regime shall be to protect and advance the best interests of current and future customers who use Dublin Airport. CAR shall no longer be mandated to have specific regard to the financial sustainability and viability of the DAA in making a regulatory determination. There will be a single-stage appeals process, which will involve taking appeals directly to the High Court. And the statutory basis for ministerial directions in relation to the regulatory process will be replaced with a requirement on CAR to have regard to current government aviation and airport policy and other relevant government policy, including in relation to national economic development policy and climate change policy. While ministerial directions are justified to ensure alignment with government policy and issues of national significance, ministerial directions on issues already incorporated into or potentially at odds with statutory objectives may undermine the independence and authority of CAR, the regulator. Furthermore, it is proposed to provide CAR with the powers of direction in its relationship with DAA to ensure there is effective consultation and transparency in setting the individual airport charges within the overall price cap, and that the charges do not unfairly discriminate between airport users. CAR currently has a similar power of direction in its relationship with the Irish Registered Airlines under Section 45A of the Aviation Regulation Act 2001. That section applies where an airline is failing to comply with EU regulations on passenger compensation and assistance for delayed flights. It is also proposed in the bill to transfer the existing ministerial functions relating to transparency of airfares to CAR, to provide a statutory basis for the periodic review of the regulatory regime, to require CAR to produce strategy statements and provide a statutory basis for performance reporting against published objectives and goals by CAR. And finally, to provide CAR, the regulator, with the power to make regulations to allow the DAA and airlines to make some commercial agreements in a fair and transparent manner on a bilateral basis without direct regulatory instruction. Taken together, the proposed amendments represent a strengthening of CAR's hand in its relationship with DAA. It is fair to say that DAA would probably prefer a different policy direction, but the approach is in keeping with the government's broader regulatory reform agenda. That agenda, which sets out in the government policy statement on sectoral economic regulation, represents a change in the overarching purpose of economic regulation, whereby it places the rights and interests of the consumer formally ahead of those of the regulated industry, in this instance the airport company. The focus of these reform proposals is to secure, through price regulation, outcomes that are in the best interests of the people who use the airport, rather than necessarily the airport itself. However, of course, a highly connected, financially stable, service-focused airport with a properly funded medium-term investment plan is in the interests of both airport users and the company. If it is agreeable to the committee, I propose now to give a brief overview of the main parts of the general scheme. It comprises 10 heads. Head 1 is a standard provision providing the short title and commencement. Head 2 is a standard provision setting out the interpretation. Head 3 amends the ability for the Minister to make a direction to CAR where that direction relates to decision-making around airport charges. In its place, Head 6 will expand on the criteria that CAR will need to use in making a regulatory determination. Head 4 puts the requirement for CAR to produce and publish a statement of strategy on a statutory footing and requires it to report on progress. Head 5 enables CAR to provide, through regulations, for regulatory flexibility. Head 6 outlines the hierarchy of objectives that CAR must strive to achieve. It sets the primary objective as being to protect and advance the best interests of users of the airport. It sets out that CAR must have due regard to government aviation policy, government policy on climate change and the promotion of competition. Head 7 replaces the appeal process, whereby the Minister will appoint a panel of aviation experts to review a determination of CAR, with an appeal directly to the High Court. Head 8 provides for a review of the airport charges regulatory regime at least every 7 years. This is in line with the government policy statement on sectoral economic regulation. Head 9 provides the power of direction to CAR to ensure there is effective consultation, there is transparency in setting airport charges, and that the charges do not discriminate amongst airport users. Head 10 transfers the functions relating to transparency of airfares to CAR from the Minister. There is an obligation on carriers to make prices of airfares more transparent, for example, making information on the full price of an airline ticket to be paid available, including all taxes and charges, at all stages of the booking process, and also in advertisements. These functions are currently with the Minister. However, the Minister considers that CAR is the appropriate body for this function, given its existing consumer protection roles relating to air passengers. The general scheme sets out the proposed changes to the current regulatory regime for setting airport charges at Dublin Airport, as set out in the National Policy Statement on Airport Charges Regulation. The measures will enhance regulatory performance and oversight, and it will strengthen both the authority and the independence of CAR. It will also streamline the appeals process. The overall approach and many of the measures proposed in the general scheme is, as I have said, also in keeping with the principles set out in the Government Policy Statement on Sectoral Economic Regulation, which was published in 2013. In summary, the proposed amendments strengthen the regulator's hand in its relationship with the DAA and refocus the overarching purpose of the economic regulation, placing the rights and interests of the consumer formally ahead of those of the airport company. It is intended that the general scheme will form the basis of the Aviation Regulation Amendment Bill to be drafted with the legal advice of the Office of the Attorney-General. To assist the committee with its consideration of the general scheme, I have provided a number of documents which outline the policy context and implications. These include the National Policy Statement on Airport Charges 2017, the Government Policy Statement on Economic Regulation of 2013, a departmental briefing document and a regulatory impact assessment. I and my colleagues look forward to assisting the committee in your consideration of this general scheme. Finally, the committee will know that last week CAR published its draft regulatory decision for the period ahead. This draft decision will now be subject to a statutory consultation phase. As we are now in that phase, I and my colleague from CAR are restricted in what we can say about the specifics of that draft determination, but we will endeavour to be as helpful around the mechanics of it as we can. Thank you.
Thank you, Mr. Gallo. Before we move on, can I ask the deputies to speak to the political heads of the bill and direct the questions at each head respectively, right? So first I'll take Deputy Robert Troy.
I'm going to let
Maybe he's going to defer to me, Cathaoir Loughlin, if that's okay.
Yes.
Agus Gurmag is ochticht Stechan of Gurmana Keshan email. I'm not going to be long, but this is just a kind of general. I'm not going to go specific because obviously all we have are the heads here of draft legislation. But the overarching purpose of the Commission of CAR at the moment is actually totally focused around the passenger, as I take it, and that's true. So the current, it's there already. I'm actually questioning why we're looking at strengthening something that's already there in some areas.
Sure. Well, I suppose the background to this was that there was an independent assessment by Indicon.
2015, yeah.
And that was quite an extensive study around DA's market power, and had the consultation and industry fully participated in that process. But Indicon made a series of recommendations, and you're right to say that it didn't represent a fundamental reshaping of the regulatory regime, but the measures are a kind of, I wouldn't like to describe them as tweaking, but an improvement, a kind of a nudging towards rebalancing, because the current Act has provisions, for instance, where it requires CAR to have regard to the financial stability of Dublin Airport.
Yeah.
So when you put that into the criteria in terms of making a determination, it kind of places the onus on the regulator to make sure that the airport is financially stable. And I suppose the view of the department is that in the first instance is a matter for the management of the airport, and that the regulator should be more concerned with setting a reasonable price cap that allows the airport to function over the period, and setting service standards within that. But actually, securing the financial stability of the company is a matter for the company and not the regulator.
Absolutely.
So,
if I may jump in there, because I just have a couple of questions, Chair, if I may, and thank you, Ronan, for that reply. It appears to me that the department are moving some of their responsibilities over to CAR. And actually, you kind of referred to that, I think, in your statement earlier. I don't know whether that's a good thing or a bad thing, to be honest with you. I think that needs to be discussed and debated. Having said that, from my own experience outside of here, in relation to CAR, I find them absolutely first class, very, very professional. I think the biggest challenge CAR might have is the resources they have, and that leads to another question, because you're talking about significant extra responsibilities and duties on CAR, and greater accountability that CAR would have and have to place then on the DA in particular in this matter, and whether those resources are available, may be made available. I'd also have questions in relation to, let's call it, the role of the department vis-à-vis the role of CAR in going forward here, because, as I say, it looks like there's been some delegation of powers, our responsibilities from the department to CAR. And the third area is, I'll just get it here, the appeal procedure. It appears that CAR will have, under this legislation, if it goes through as is, I suppose, practically absolute full authority without an easy access to appeal. It appears that the only way of appeal here, Chair, is through the High Court, which is incredibly onerous, very difficult, takes a lot of time, and is very, very expensive. And I really believe if there should be a much more accessible, less expensive way of appeal. My last point is, and this is in relation to the DAA specifically, just from my previous experience, airlines use mobile assets. Airports have fixed assets in the ground. You cannot move the tarmac. So for an airport to attract an airline can move from one airport to another. And Dublin Airport, carrying roughly, I think, 85% of all the passengers in and out of Ireland, 30 2 million or so this year, approximately. They're in competition with other airports in the UK and in Europe for international traffic. And I'm just concerned that we make sure that there is some form of safeguarding there to allow them to compete on a level playing field. And I question whether this type of regulation stroke legislation is in existence for other airports. As far as I know, I think the only airport that something like this is in existence for is Heathrow Airport. I haven't come across, and this is just preliminary research that I've done, that this is not there in relation to other UK airports or most other airports in Europe. So just if I may, Chair, Ronan, if you could maybe just reply and I suppose enlighten me in relation to those questions.
Okay.
Might just take them in turn. In terms of the transfer of responsibilities, within the general scheme, what we're talking about are one set of consumer protection powers around transparency and airfares. And I suppose the rationale is that it's not policy, it's implementation of consumer rights. And it was in a way to bring clarity, because CAR has established, certainly over the last number of years, a profile and a reputation that, in other words, people know that it's there and they know what they do. And albeit it took some incidents to draw attention to that, but a kind of a one-stop shop, if you like, for consumers to make complaints and to go and seek advice. So that was the logic, and we are obviously always in discussion with CAR about resources. That happens on a 6-monthly basis, on a rolling basis, and if there are resources that come from those extra functions, then we will consider those. It's not clear to me with this one that it actually fundamentally changes what they need to do, but that's something obviously that we will discuss with them, and it won't be. We certainly won't be asking them to do things that they don't have the resources to do. In terms of the other changes in the general scheme proposed, in a way, it probably, I suppose our view of it in considering it is that it doesn't add additional responsibilities or accountability to CAR, but it certainly gives it extra powers and authority, and in a way that probably will make its job that bit easier in terms of compliance. On the appeals procedure, obviously something we will debate throughout as the general scheme moves to a bill. That proposal is essentially just following in line with government policy under the 2013 economic regulation policy, which amongst its recommendations, yes, is to streamline the appeals process and just use the commercial courts as the point. What we have at the moment is that the Minister, as an interim step, because you can always obviously go to the courts as a final step, appoints an expert panel, and I suppose the sense overall in terms of government policy is that there are ad hoc panels in various pieces of legislation, and often the impact of them is really a kind of a stepping stone where we, if the matter is substantive, it ends up in the High Court anyway, and the idea is to shorten that so we have some regulatory certainty. The other point in terms of the costs, I suppose the experience, and I haven't been involved in it, but what I understand is that through even the ad hoc appeals process, depending on who it is that's appealing, and let's be clear, the appeals are by either Dublin Airport or the two big airlines, Ryanair and Aer Lingus, is that the various parties lawyer up and engage in quite, it's an expensive process even at that. So this is not High Court access to individual users, because they tend not to be, they haven't been so far parties to the regulatory process. It's the airport and the two big airport customers that engage in the process. On the overall regulatory policy, the fundamental principle around price regulating Dublin Airport is established existing policy, but obviously we tested that with the Indicon review, and the advice from that process was that DAA had substantive market power, and that market power, that dominant position, justified a continuation of price regulation. And you point out that Heathrow has a similar level of regulation. And again, that represents Heathrow's market power within the British market, albeit it has substantially more competition. I suppose where Heathrow, its competitive advantage is on its scale and its connectivity. So even though you have, the other London airports in Manchester and Birmingham, well, the other London airports don't have anything like that connectivity, and Manchester and Birmingham aren't near London, so it's dominant. And Dublin has that. I suppose additionally, the market assessment of Dublin's power was that its customer base was essentially the entire island. So albeit that the other airports provide services and are able to compete, if you had Dublin Airport unregulated, the risk would be that it would extend its market power, and that would have a negative impact on the regional airports and the other two state airports, as well as the airports in the north.
Okay. I still think, and I'd suggest maybe consideration be made in relation to some sort of an appeal process from CAR before something like this go to the High Court. Because there are quite a number of small little airlines as well. The two larger airlines carry in the region of 80%, I think, of all the passengers in and out of Dublin Airport. And I'd be very supportive of CAR, quite frankly. I think they've done a brilliant job. And also the airport charges in Dublin Airport are, on balance, on the lower end of charges for airlines compared to other European airports, quite frankly. And CAR obviously have a lot of involvement in the success of that from a passenger perspective. I'm just concerned to make sure that we also be fair to the DAA, quite frankly. They do a critically important job, and I'd like to keep them very much in focus in relation to their ability to do their job as effectively as they possibly can. Obviously need an oversight, so that fully agree with that. I'm also a bit concerned about the department maybe passing over maybe the ability to make, let's call it, ministerial direction and so on. That's a key area, and I'd maybe like to see what's the purpose of that, or where that's coming from.
That one in particular, I suppose to be clear, it's specifically in relation to the regulatory decision that CAR makes. So there are general powers of direction that the Minister can give around other issues, and we're retaining that. But what we're specifically doing is removing the ability of the Minister to engage in or cut across what CAR might be deciding based on its analysis and its the regulatory process. That's a point of policy principle, I suppose, around what does independent economic regulation look like. And for so long as you have the fallback of a minister being able to potentially, not that it's ever been done, but potentially, instruct the regulator what the outcome needs to be, that doesn't lend itself to being described as independent regulation. So part of it is to strengthen that. But be clear, CAR, I suppose, as we take that away, what we require is that CAR has full regard to national aviation policy and other relevant government policies, including climate change, and that puts the onus on the Minister and the Department to be very clear and what its aviation policy is, and to make sure that that's up to date, so that CAR can reflect on that. So we certainly aren't weakening the Minister's authority. It's just one area where the Minister has agreed it's not really appropriate that he retains that.
And if this goes through into legislation, then who will CAR be accountable to?
Well, we're putting in to the bill on a statutory basis that it has to produce statements of strategy. It has to produce performance indicators, and it has to report to the Minister on the basis of that.
So it's accountable to the Minister and the Department?
And to the Oireachtas.
It will continue to be?
Absolutely, yeah.
Okay, thank you. Thanks, Chairman. Thanks very much.
Deputy Troy.
Thanks very much, Chairman, and thank the officials for coming before us today. I suppose Senator Ó Céidigh hit on it there a minute ago in terms of the current charge has been set down. This has all been done in relation to amending the charges that are currently be charged by the DEA at Dublin Airport. That's the only airport that is going to be affected by this. But can I ask then, in terms of the existing charges being charged by Dublin Airport, how competitive how competitive are they in comparison to their counterparts across Europe?
I'll just see if I'm not sure if I have the specific detail. I know. Generally, DEA is Dublin Airport is good value and competitive on price. I'll see if we have the specific information. I don't have it to hand, but
I'm told they're the second most competitive airport of their category in Europe.
yeah, that's probably true. Yeah, and it's a good thing.
Oh, it's a great thing because you know the fact that they are so cheap, it means that they're able to attract more people into them and utilise the airport. And the bottom line, it's the passengers who benefit the most by competitive charges.
And they've maintained that level of competition while building out Terminal 2 and expanding their asset base as well. So
suppose the question is then, if they are so competitive on an international basis, and they are, why then is there a need to change the structure in terms of how the charges are being applied? Certainly, if it was a thing that were out of sync with their European counterparts, if it was a thing that were price gouging and charging unrealistic prices, and our customers or their passengers were being ripped off, there's a justification to amend the practice. But what's the justification to be coming forward with these amendments now?
I suppose, and this maybe speaks to an earlier point, certainly the regulatory review that was undertaken found fundamentally that the current regulatory regime is working, and that speaks to your point as well, that there's not a huge amount broken. But it did have a series of recommendations to say, look, as an outcome of the review, there are improvements that can be made, and we certainly wouldn't characterise them as being fundamental improvements, and nor do we think that they will necessarily result in fundamentally different outcomes. But with the review, which came about a year or two after the broader economic regulatory review that the Department of Taoiseach undertook, the decision was made to make those minor, improvements around how the legislation is pitched. So fundamentally, just being clear that first and foremost, it's the customers, and we say the customers, we mean individual people who are walking through the airport, that they have primacy of import when the regulator is thinking about the future development of the airport. As to whether that gets us to a different point in 5 years' time in terms of regulatory determination, I don't know. But I suppose that the view was that there are improvements. There are, and therefore, as we do, if we are committing to doing periodic regulatory reviews, which is now becoming embedded in various pieces of legislation, it's rare enough that you will do one every 5 or 7 years and find fundamental flaws. But if you don't make the incremental improvements as you go through, well, then at some stage you may have to make fundamental improvements. So I think that's the idea, is that we just make incremental changes. But yeah, I think you're right, Deputy. We wouldn't characterise this as being something that's obviously broken. It's a tidying up.
I suppose that makes me ask myself the question at a time when the department is very busy and have to prioritise legislative proposals and coming forward with legislation at a time when we're still, and we'll come back into the main chamber later on to finalise, hopefully, the independent noise regulator at the airport. Why is there an urgency, or why is scarce resources being attributed to put through a piece of legislation that fundamentally is going to bring no difference? You're acknowledging that yourself today, and that just makes me think, is there another agenda at play? Certainly not by the officials, but is there an agenda at play to bring in a mechanism which would actually force the airport to reduce their charges further, and taking out that particular point which acknowledges that the viability of the airport must be part of the consideration, because this is our main gateway. This is our gateway to connect Many of our high-end produce with foreign destinations. This is our gateway for our tourism industry, and sometimes it's forgotten just the importance of that indigenous industry to this country. 280,000 jobs rely on the tourism sector. And I would have a fear that perhaps these changes could result in the DAA pulling back from carrying out much needed infrastructural investment that's critical for the airport to grow. And when you look at, I know you've acknowledged that the current charging regime facilitated Terminal 2, something that your current political master railed against when he was on the opposite side of the House. But we need much needed investment in terms of new landing spots, new gates, new taxiing facilities, and indeed the huge investment that is the second runway. So I would have a concern, and accept you're coming in here and it's pre-legislative scrutiny, we're at very early stages, but I'd have a real concern that the changes are going to have an impact, a possible impact, on DAA's ability to carry out what's needed. Especially, as I said, and we can't lose fact that we have to be on the side of the passenger going through, getting value for money, ensuring they're not being charged exorbitant fees. But here today we acknowledge that we're one of the most competitive, if not the second most competitive airport in Europe. So I just question the need for this at this current time.
I mean, maybe come back on that. It's a bill that, a couple of things that this is a follow-up to is a commitment that's in the National Aviation Policy to carry out the review and then to implement the findings of that review. It's true to say that this isn't, as I said earlier, a fundamental shift or a change, but there is a rebalancing, a refocusing of it. And I suppose what we come back to fundamentally is that we're dealing with an airport that has a market-dominant position. It's probably not fair to characterise it as a monopoly, but it's as close as you would get to one. And therefore, what the review spoke to is that we have an effective regulatory regime, but also the fact that regulatory regime dates from 2001, and provisions such as ministerial directions are, in a way, of their time, speak to a period where policymakers were probably trying to we're not fully convinced about what independent regulation looked like. So if you go back into the 90s, you had under a lot of legislation, you had the state departments setting prices for various things, including electricity, and of course you have a step away from that in line with European regulations and general regulatory trends. So I suppose what we're doing is updating it, acknowledging that actually it was pretty well conceived at the outset, but in regulatory, the principles of regulation, independent regulation, the idea that the minister would have this power of direction just doesn't sit with that. So is this a critical piece for the Oireachtas to be setting aside time for? No. If it doesn't happen, will the country be worse off? No. But so it's one of those pieces of legislation that's nice to have but not urgent, and we're certainly not pushing it forward as something that has to happen immediately. But we do think it represents an improvement on what we've got, and I suppose we can test that as we go through. In terms of the impact or any kind of ulterior motives, it strengthens CAR in terms of how it engages with the DEA. Department review that as a good thing. The department has, obviously, DEA is an important national airport, important national asset, but well able to look after itself in all its dealings around the place. And importantly, anyway, CAR will have to have regard to national development policy, national economic policy, aviation policy. And in that respect, it will have to ensure that we have an airport that's functioning properly and financially stable. It's just, I suppose, just when you go through a piece of legislation, you see requirements on the regulator to make sure that the airport is financially stable. It looks a bit strange when you have a board and a senior management team who are well resourced and their job is to run the airport, to have a statutory obligation on the independent regulator to be worried about that sits a little bit at odds with that.
I've no difficulty with the board's ability to run the airport. As you can see, how it has thrived over the last decade in terms of their passenger number, and the fact that they're second most competitive in Europe. It ticks all the boxes in terms of doing the right thing. But my concern is the fact that if there is a possibility to further drive down the charges, will that have a direct consequence for the airport's ability to grow, for the airport's ability to make the much needed investment, and ultimately, if the much needed investment is not made, that will have an impact on the airport's ability to generate further employment. It will have an impact on the airport's ability to ensure that the passengers, when they do arrive there, can go through the airport in a timely and efficient manner. If we have a situation where we don't have appropriate number of landing bays, taxiing ranks, whatever, there is a possibility of ongoing delays, and that will have an impact on the quality of service that the airport can provide to the passengers. So while the charges might be minimally or a small bit lower, their experience could be adversely affected, and I'd have a concern about that. In relation to strengthening CAR, will the extra responsibilities that are being moved over to CAR and the strengthening of CAR, will they now require additional resources in terms of personnel, or are they adequately resourced in terms of meeting their new obligations if this legislation is passed? And finally, is there any indicative time frame as to when the legislation will be introduced at second stage, or what's the time frame for moving to the next stage?
Maybe touch on in terms of the impact or the risk or the threat of reducing caps charges. I suppose to understand the regulatory process, which won't change, the mechanics of it won't change under this proposal. CAR take a view. I mean, DA makes a pretty substantive submission, so to the airlines, around what their 5-year, their kind of medium-term development plans are, and what their forecasts of passenger growth are. What the regulator takes account of then is the existing capital stock and what it takes to maintain that capital stock, and the return on what the DA returns on that capital stock. It takes account of depreciation. It estimates future operating expenditures and what an efficient operation would look like. And then it takes away its commercial revenues, obviously, that the DEA can make from car parking and other sorts, and retail. And this multiplied with passenger forecast then gives CAR a kind of a basis for saying, well, look, this is a reasonable revenue and income stream for you to be able to provide the facilities for this passenger growth into the future. And while they take a view, and that's a 5-year determination, it obviously, if things happen in between that run counter to some of those assumptions, then CAR can go back and look at that afresh. And really, I suppose the points of disagreement between the regulator and the regulated company is round the margins, as these things tend to be, in terms of how much the company thinks it needs to grow and how much the regulator does. And that kind of tension is a good thing, and in a way the whole point of it is that it replicates competition, so it puts there's no doubt CAR's job is to put pressure down on DEA's costs. That's actually what they're trying to do, but at the same time they're statutorily required to make sure that the airport succeeds. I suppose I would say over the period of all of the determinations that CAR has had, the cap has fluctuated. So it has been as high as over €11 in 2010. It has been as low as €5.50 in 2005. So it varies depending on what capital projects the airport has and what the passenger growth is to be. So I suppose to finish off on that point, there isn't a risk of there being a medium or long-term impact on DA's ability to do what it needs to do for the economy. Right? It's about the nature of the regulatory debate, the argument, around the margins, I suppose, and that's probably a healthy thing for the DA to be run through. On the resources, I suppose there's an ongoing engagement with CAR. There's a general review that's been carried out by CAR, and they're discussing with us around their capacity, their resilience. In the context of this bill, but in the broader context of its consumer, particularly its consumer protection functions. And that piece of work has been done by CAR. We're in discussions and seeking to see what extra resources it needs. It's obviously a small unit, but there isn't, I would suggest, unless David has a different view and he's entitled to if he does, within this general scheme, I don't see this being a huge driver of resources. But there is a resource challenge for CAR generally, and we're looking at that. Time frame, I think we're looking, we certainly would like to be in before the end of the year with maybe a draft bill in autumn. And if we can get to second stage around that piece, that would be good. But obviously there are other bills that are priority, so we'll see where we end up on the list.
All right. Deputy Troy.
That's okay.
I suppose just before we conclude, just one comment or ask a question. Given this proposed legislation, and it's all about comparing our stats with other major airports in Europe. In regards to smaller airports, is there a knock-on effect, positive or negative, in regards to their operations, costings and so forth? Like Cork, for example, depends on the DA, like, you know.
Probably a matter of some debate, I suppose. What I would confidently say is, well, none of the other airports in Ireland are regulated, so they're free to set the price whatever they want. Obviously, in setting a price for Dublin, you essentially, it becomes a kind of a market price or reference point for everything else. What I would say is, if Dublin Airport wasn't regulated, then it would, it would be able to operate as a kind of, very market dominant firm, and I suppose it's reasonable to conclude that wouldn't necessarily be good for the other airports in terms of Dublin Airport's ability to encroach on their customers. But so the regulation is a good thing in terms of keeping the DEA growing, but in line. But I suppose there's not a direct link between the price set for Dublin Airport and the other airports, other than it's a reference point.
Thank you. Right. I want to thank our witnesses, Mr. Ronan Gallagher, Mr. Michael O'Connor and Mr. David Harnett. And can I ask the members in the committee now able to conclude this consideration of the general scheme of legislation and economy report back to the Minister? It's agreed. We'll say yes. Accordingly, the transcript of this meeting shall be deemed to be the report of the Joint Committee. The meeting is adjourned until 1:30 p.m. 29th May next 2019. Thank you.